Hello and welcome to yet another episode of Legal Wrangle, India's first video head note brought to you by TIOL Tube. In this episode, we are covering 5 important judgments relating to indirect taxes. Let's start with the service tax case, and the assessee here is Mackintosh Burn Ltd.
The assessee, along with 50 other assessees, has claimed that no service tax is payable on the fees collected as subcontractors appointed by the executive agencies under a Memorandum of Understanding entered into by the Government of India for construction of border outposts.
The issue is whether the activity or service of border fencing across Indo-Bangladesh border is a service falling under the definition of erection, commission or installation as prescribed under Section 6539A of the Finance Act 1994 or otherwise. Let's go to Purnima for the facts of the case.
The primary assessee, a contractor of numerous architectural marvels and structural masterpieces, was assigned the task of construction of border outposts for BSF and road along Indo-Bangladesh border. For this work, the assessee was compensated by way of a fees at a certain percentage of project cost. A demand cum show cause notice was issued alleging that the activity of construction of border fencing is chargeable to service tax under the category erection, commissioning or installation services.
The Commissioner observed that fence refers to structure and the service of erection of fence satisfies the definition of erection, commission or installation service. Therefore, he confirmed the demand and imposed penalty equivalent to the amount of service tax payable.
The Cestat held that fence, even though a structure, cannot be read in isolation but has to be read along with erection, commissioning or installation, and also with the objects of service tax levied, that is, plant, machinery or equipment.
The Cestat hence ruled that it was not possible to accept the department's view that the service of erection of border fencing structure standing alone would be subjected to service tax under clause 39A of section 65 of the Finance Act.
Thank you, Purnima. In this case, interestingly, Revenue argued that both circulars should not be read as statutes and are merely clarificatory in nature. Fencing on Indo-Pak border not taxable? The tribunal was informed that there was no demand for service tax on identical fencing in the Indo-Pak border. Let's move on to our next yet another very interesting case of service tax. And the assessee involved in this case is a famous Tollywood film star who has argued that he should also be granted the benefit of exemption notification as allowed to theatre artists. The key issue in this case is whether the benefit of exemption notification number 25/2012 available to theatre artists can be extended to film actors also. Let's go to Purnima for the facts of the case.
Yes, Maneet. Assessee here is a film star who filed the present writ petition questioning the notification granting service tax exemption to performing artists in folk or classical art forms of music, dance or theatre. Assessee submitted that his job involved skills to display different kinds of emotions and dialogue delivery. Such skills are not different from the skills of an actor who performs with similar skills in theatre or drama.
Before the High Court, Assessee contended that the impugned notification is arbitrary and discriminatory as it benefits only performing artists in theatres and drama and not film artists.
The High Court held that it was towards the object of Article 229 of the Constitution of India that a beneficial endeavour has been made to give support to native art and culture and encourage them as they suffer from financial constraints. This is not the position of films.
And therefore, the assessee, a film artist, would not be able to claim exemption under the service tax. Our next case is regarding the rebate of service tax claim.
The assessee involved is Ambe International.
The key issue here is whether an appeal against the order of Commissioner Appeals regarding such rebate lies with the tribunal or not. Let's hear the facts.
Assessee had a service tax registration under the category of manpower recruitment and supply agency. It claimed rebate on the services exported out of India, which was rejected by the Assistant Commissioner on the ground that the assessee had not submitted complete information in support of its claim.
Cestat held that, as per provisions of Section 35B of the Central Excise Act, no appeal shall lie to the appellate tribunal and it has no jurisdiction to decide any appeal in respect of order passed by the Commissioner Appeals in a case of rebate of duty of excise on goods exported to any country or territory outside India.
On further appeal by the Revenue, High Court held that the tribunal has clearly missed and omitted the consideration for subsection 2A of Section 86 of the Finance Act. This clearly mentions that the tribunal has identical power in order to dispose of the appeal as per the Central Excise Act. In short, it held that the appeal was competent and maintainable.
This appeal was clearly maintainable and should have been entertained and decided on merits.
The Delhi High Court had earlier given an identical ruling in the case of Glyph International. This courtroom battle has now entered the Parliament. In the Budget 2015, the Finance Bill proposes to amend the Act to stipulate that in such cases, the appeal does not lie to the tribunal and the matter has to be taken to the revision authority. Let's move on to our next Cestat decision in the case of Ankur Packaging Private Limited. The key issue is, when scrap is retained by the job worker, sale of the same will affect the conversion charges towards job work and hence the same should be included in the assessable value of the job work goods. Purnima will let us have the facts of the case.
Assessee here is a job worker. On factory visit, it was observed that the value of scrap generated during manufacturing process has to be added back to the assessable value of the goods manufactured since sale proceeds of such goods was allowed to be retained. It was the contention of the department that the value of job works get reduced to the extent of scrap value allowed to be retained on its sale. Assessee paid the differential duty along with the interest but without any protest.
Thank you, Purnima. Later, the assessee realized that they were not supposed to pay the excise duty on the value of the scrap and therefore filed a refund claim for the amount of the duty and interest paid, which was rejected by the original authority but allowed by the Commissioner of Appeals.
Cestat observed that against overall activity of job worker is getting the consideration in two forms. One, job work charges, and second, realized value of scrap sale. Thus, total sum of both these elements will form the total consideration received by the respondent towards job work, and the sale value of scrap is includable in the assessable value of job work goods.
The Cestat has made clear that an assessee acting as a job worker has to include sale value of scrap in the assessable value of job work goods for the purpose of computing excise duty. Well, our last case is of Tamil Nadu VAT dealer Sree Kumar Engineering Works, which came up before the Madras High Court. The document required for availing credit was lost by the department, and the assessee was asked to file an indemnity bond. The interesting issue here is whether the assessee can be denied benefit of credit on the basis of duplicate copy of such document available with the assessee.
The key issue before the High Court was regarding the liability of the assessee in case of loss of original credit documents because of the fault of the department. Can the assessee be made liable to make declaration in the form of an indemnity bond?
The revenue argued that as per Rule 12, Sub-Rule 2 of the Central Sales Tax Rules, when C-form declaration was lost, it was open for the assessee to furnish indemnity bond to the notified authority. To know more about the facts, let's turn to Purnima.
The assessee, a dealer in magnesite powder, has handed over Form C in original relating to the turnover to the commercial tax officer, for which an acknowledgement was also given by the department. Subsequently, the revenue passed an order stating that C form was not filed by the assessee, and therefore the assessee had to file a declaration in the form of an indemnity bond, otherwise it would not be given any benefit of credit.
The High Court observed that the relevant Rule 12(2) can be made applicable only when the document is misplaced by the assessee. An assessee cannot be made liable for indemnity bond for no fault of it.
The High Court held that when the Revenue Authority had misplaced the original document for whatever reason, there was no hard and fast rule to deny the request of the assessee for accepting the duplicate copy of the document, which was available with the assessee.
This decision of the High Court reiterated that the assessee cannot be held liable for the department's lapse. This brings us to the end of this episode of Legal Wrangle. Thank you for being with us. Please mail us your comments and suggestions at editor@tiol.in. See you again next week on Legal Wrangle for Direct Tax.